Very good morning, friends. So I'm sure past many sessions you must have taken the ride in a very positive manner. Today it is the last session for the course which we conceived for all of you, the students, the members, the faculties, the intellects out there to go through, and something which we felt is direly required, which is needed for our students, even for the faculty members, as in a brush up thing, to take it over, to have the latest things, what is going around, and how it all started, the digital, designing this digital solution course. So what we did, since all past sessions, you must have observed that we roped in industry experts for all kind of different sessions. I admit they must not have been a very detailed sessions, but a teasers for all of you to provide the insight how it is going around in the industry and what all is required, expected from the fraternity out there. What we felt, our students who are going through the day in day out courses, we generally are not abreast about the latest things, what is required, like we say AI based stuff, we say machine learning, we say mind mapping, brainstorming, critical thinking, design thinking, then how to present and communicate the stuff. And this is something which we lack. I admit, all of us, we do present, we do work hard, but what we lack is how to present ourselves, how to communicate the stuff what we have actually designed, what we have actually delivered. That's how this course was conceived, and this is the last session. You guys are interacting with me, Mohit Gambhir, and many of you are already aware of myself. And we moved in a session by session basis. I'm sure you guys must be providing a lot of feedbacks, which has already been done, what we are trying to. And since it's just a beginning, I must say, there is a lot of scope to improve, to improvise, to get the feedback, and everybody of us is in together. This is just a beginning, a very humble start we took off based on the suggestions we received from the students across the country, and I'm sure this will take a long way ahead. It will cross leap and bounds once more and more industry experts and volunteers, they will come in, they will rope in to take this kind of initiative further. Today I am here to talk about more related to patents, related to IPR, what it is, why it is at all required, what is the need of protecting our IP. So I'll begin by saying that research, you must have observed the very consistent scenario that is going around. The moment you enter in a classroom, that is the year one, by the time you reach the mid of that coursework, the technology available is almost changed. It's no more there. And during our days, I believe way past 8-10 years ago, it was a scenario. We were very much aware that once we enter into an engineering course and or any other course, we are aware, or we were aware of that down the line, 4 years after, 5 years after, this thing is going to be there. We will work on this in this technology. But the pace of technology change, what is happening, by the time you come in the first year and by the time you reach third year, it changes. Rather, the first year thing is no more there in the third year. Examples, maybe if I give you, it's fintech, blockchain, AI based kind of technology, the deep learning stuff, the machine learning stuff, which was a couple of years ago, it was not there at all. So it's like, where are we lacking, or what things we should do actually, apart from getting abreast with the basics, the stuff, fundamentals, which is the most necessary thing which we guys should be aware of, that how the basics are being governed. And minded students, everybody say that why we are reading this old age stuff, why we are doing this. But if foundation is strong, certainly you can build a very high rise building on it. and that's what here it is. So what we have to do, have a very solid blend of the fundamental courses in tune with the latest technologies and the latest stuff which is coming in. So research component, which I always emphasizes on, which I say that in our higher education, it moves on. We should do research more and more, and as you can see in the first slide itself, I emphasized that goal of higher education is to train our students or educate our student to develop more creative thinking mindset, to move into a kind of set where they can they can become a design thinker. They can know that how, yes, they are aware of this is the way. So it's like improving their thought process. How we can do it? It's about improving the scientific research, that is, train them in doing research. That applies to everyone, even to our faculty members, even to our students, everywhere sitting out there. So like if our faculty members, they are able to do a world-class scientific research, obviously the students, they will get the benefit out of it. And if they are not doing it, then I believe they will just become the bookish kind of knowledge they will acquaint. So it goes hand in hand. And where are we sitting today? The research plight, and it's not like for everybody this is the case. Majority of the case it applies. The thing I'm going to show in my next slide. So here it is. What we can see, there is a cage around here. We can see a chicken, that is the grown-ups, and how I relate it, the people like my age, if you see, we are confined in a cage. We do not want to see the world from the perspective of others, of the kids. Maybe kids are curiosity driven. If you just look into it, we say it's like a chicken, and it's going around in the cage, and there are seeds and bees out there, but that chicken is moving out. Actually, it's a curiosity driven. So by curiosity, that student, they move out. So it's like about the faculty members, the staff, which we need to shape these kids in, and which we need to take their hand along. We need to become a very good mentor out there. So we need to improve the state of research where we are doing. Today's topic is, like again, as I said, it's patents and IPR. So it's a very funny thing around that, a cartoon, a script which I tried to gather out here. It says, all I asked was, can I patent my copyrighted trademark? I'm not sure how many of you got this, but who are aware of IPR or patents or trademark, they must be very, very well, they must have acquainted with us. Like, you can either get a patent or a trademark or a copyright. You cannot get something in tandem in together. So now, as we started, it said, why IP? IP, it provides you the exclusive rights. It's an incentive to an inventor, the benefit. So like, why an inventor is doing inventions? There has to have something for that fellow, he or she, who is investing their hard-earned money, their time, their effort, their energy, or more or less their brain to educate others, to bring knowledge into give that knowledge a shape. So what happens? Like, once we protect that IP, each time, every time we buy that protected item, we are helping that inventor grow. We are motivating that inventor. That becomes an incentive for that inventor. That is the time, energy, money, thought process, all those kind of efforts that has gone into developing that particular invention. It also encourages new talent, and more or less, the last but not least, it creates or gives the credit for the creators. It gives them full recognition that, okay, yes, this thing belongs to these fellows. Coming to the stuff, and which we, all of us understand, I believe, very genuinely, that where the money is. Now, if you go why IP and economical statistics, which I try to gather here, 2/3 of the value of large businesses in the US can be traced to an intangible assets. You can go through some figures. The figures are written out here. Dow Chemical, it has $125 million kind of estimated annual earnings from IP. You go down, scroll down, like Bayer, $300 million, DuPont, $450 million, and then you say Lucent, it says $500 million, and coming down, Qualcomm is $800 million, IBM is $1.5 million. I'm sure this is humongous figure. So I'm not sure, is it right or wrong? Many years ago, I read a statement out there that if in a company like Status, I just named $1.5 billion. So if nobody does nothing Everybody will be paid in full because they have so much of IP licensed, even if they don't pick any needle out there. So that is the power of IP. And in our country scenario, I'm sure many of us would have already started inquiring that why I have bought in this data of US. The challenge in our country is we do have the data, but the kind of revenues we guys are running from licensing, it's pretty small. We need to increase that. Obviously we guys work together, we guys put in a lot of things, but what we lack is we do not document things, we do not maintain the appropriate dockets, we do not put the dates, we do not genuinely file IP, and even if we do, then we do not know how to take it forward. So that is the kind of ecosystem certainly we need to develop, and we need to take a sail forward. And in this session, I'm not going to generally teach you how to file a patent. I'm going to tell you why it is at all important, and why IP is required in such a bad shape, why we need it. Because country's whole economy, it depends on intellectual assets, and the way things are shaping in this real-time world. Countries like US, China is picking up fast, and very soon, once and after my few slides, I'm going to present few more data points, and you will be surprised to see how and where we are sitting and where we are standing in terms of IP. And for consumers, again I say why IP is at all required. We get it protects the consumer and families. It says the educated choice they have made. Product what you buy is genuine, they are of high quality, they are real-time, the good products which are already have some IP protected, so that it becomes a sort of again a ecosystem. You buy IP protected item, the fellow who developed it, who made it, he gets the incentives out of it, he gets more encouragement, and he puts in again more high quality products out there in the market. So that's the reason you must have seen many times it says fake items, fake products, fake goods, and we should not actually encourage, and even they may harm us. We can take an example, like if you say you buy a fake shoe, it might be a case the product or the leather, or that may not even be a leather, that may harm or may create some kind of allergies to your feet. So that's how it's all about tried and tested kind of thing, which is protected and can be taken care of. Generally we say IP, it is now what IP from where it comes from. It's a like creation of human intellect, that is our brain, what we do, it is our knowledge assets, and it is something which you cannot see till the time you bring it on the paper. That is, you put in, you make more and more invention, you generate patents out of it, you generate trademarks or copyrights, whatnot. So for a business, for any business, IP, it's a real key component for a success. And if we say IPR, it's a real wealth for nations in today's tech scenario. The people more and more, we are working in the knowledge economies, the AI kind of scenarios, the machine learning, the computers, and this all started when IT8 started. So we, or rather much before that, we have some patents filed. Like for US it was in year 1750 or 1780 something. In India it was 1856 to be precise. So I'll be coming on with those data points in the next slides. Again, IP, it's not a tool of exploitation. Many people out there, they believe that if we file IP, it will stop us, it will, you know, we are not going to develop this, and we will be confined to a thing, it will grant monopoly to somebody else. But my dear friends, it's not the case. It is a tool for empowerment. It's like you are inventing something, you're getting your due. It's on to you. You can get your IP granted, you can let it free for the people outside there, you can charge, you can license your technology. So it's on to you, but you should, it's a thing that any human being or any individual who is developing something, he should be amply or appropriately be recognized. So recognition is first thing that keeps that researcher motivated, and then it can be taken care of. So it's there will be no self-relied innovation, if I say, without protection of IPRs. So that's the reason it is direly required, it is direly needed. Now in talking to university scenario, if we say, and in the slide I'm not sure whether it is pretty much visible, and pardon the brevity which I try to get the data in, but this is something which I try to collate that why research in universities are important and why IPR or patent protection is more important. So something which changed the world here I am presenting, it says seat belts, which is again Cornell University product. If you see there, it's written. And then the internet, numerous research innovations and universities that helped to make this internet what it is today. And I'm sure without internet even you will not be watching this session which I am delivering. So it has changed our world altogether. We have entered into a revolution from where the information dissemination occurred and how it penetrated to everyone sitting out there across the world. So that's the beauty of the internet. Then chemistry, we say periodic table, that is the first version. It was created by a professor in the university. Then we have rocket fuel, we have Gatorade. This is the energy drink, we say. It has been developed at University of Florida for athletes. Then we have flu shots, we have chemotherapy drugs, we have solar power. And we have a lot of other inventions which are coming from the universities, from the research labs in India too. We have a lot of inventions coming out labs, and I again am going to present the data points pretty soon. Here what we have is top 5 Indian applicants rather, that what it is going around, the current scenario in India, and the data source which I have used, it's the Indian Patent Office 2016-17 report, whereby they have compiled the data and they have presented the study for all of us so that we can garner, we can move on, and we can certainly get into more enthusiasm to do more and more invention. So if you see IIT's collective here, we have approximately 400 patents, and these numbers may offshoot by plus minus 5%. I'm sure by the time I have collected, it must have improved or new data points must have arisen. Then you see Wipro, it has 226 applications filed. Then we have CSIR Labs, it says 225, pretty close though. And then we have Mahindra and Mahindra Limited, it says 205. Then we have BHEL. So you can again see overall out of top 5, if I say there are 3 government enterprises, the research houses which are coming in, and the IITs, they are being academic institutions that's coming in. So next I'm also going to present the state of our universities, the academic institutions, that what kind of IP or how much IP the research they are putting in, they are filing in, and how we are moving ahead. This is the IT. As I said, we are living in the IT age, information technology, and so how many companies they have put in, that is Indian applicants. You can see over there Wipro, it's there, it's 190 applications filed. Then we have Tata Consultancies, it says 159 applications. Then we have IITs, which is again, so this is, I am repeating, it's in the field of IT. It has nothing to do with all together or something. Then we have and that's the reason you are looking at the companies which are in primarily IT space. Then we have HCL Technologies, they have around 35 applications filed. And then last we have Huawei, and it says 29 applications filed. Next data point which we are coming at, it says how many Indian applicants for patents from scientific and research development organizations what we have across the country. As the name you can look at, it's the CSIR Labs, it says around 230 applications it's filed. Then we have DRDO, Defense Labs, it has 58. And the number goes on, like we have GHR Labs based out of Nagpur, they are 50. Then we have Indian Council, ICAR Labs, they are 41. HO Research Foundation, 23. Alinov, 20. And MSN, it's the 19. LNT Labs are there, they're 18. Sun Pharma, 14. ISRO, we have 13. GSP Crop Sciences, we have 13. So this is something, the number from CSI, the scientific and research development organizations which are coming in, and this data is, again I'm repeating, 2016 and 17 data points. So as on today it must have improved. And this data coming in, I said, from the institutions and the universities which are lined up. You can see over there we have 400 from the IITs, then MIT University we have 106, and during that particular year, again you must be reading in the newspapers, and these academic institutions are claiming they have much more IP, so they claim, and altogether this is what I have presented in that particular year. So then IISc we have 54, then Welltech we have 50, Then we have GH Raisoni College, Nagpur, it says 49. Bharat University, we have 45. CGC, that is Chandigarh Group of Colleges, 30. Chitkara, 29. Hindustan, 28. NIT Collective, we have 26. So now why I presented this data points, I'm presenting this. It is the current state. What is going around in the country and how we are moving in. So it's not about these institutions, the academic university and the universities which are there. It's this research which is being carried out there, the students who are joining hands with their faculty members, and they are putting in the effort to move more into IP based economy kind of things. And why it is at all required for any university, any institute to file patents. You can see this. It says the royalties earned by patents, higher education in US again. It says University of Florida. It has more than $94 million in royalties since 1973. My God, it is really humongous, the figure. The next figure, if you see, is NYU, $650 million deal with Royalty Pharma in May 2007. So these are the data points. If you guys see, if you guys actually introspect, and this is something this has nothing to do with that these are the best figures, these are the small figures. This is something which I just encountered, just came across for, I thought to present. In India, we are in the shape of coming in with tech transfer mechanisms, with commercialization kind of things, which we lack generally, and we are moving in those things. So once we have that kind of ecosystem established, we can pretty well see that the licensing things and the revenue things will improve for our universities as well. But this is the case. You go to Berkeley Labs, they have a lot of IP being filed in, IP being generated for Stanford, for all kind of institutions. They are generating that stuff. And even in our country, if we do this and we have an appropriate tech transfer mechanism, the research which is coming out of universities and academics, certainly we can develop a lot of indigenous technologies out there, and we can save a lot of import duty which we are actually paying in to the countries. So that is something why I believe you guys understand that IP at all, and in university scenario and at the level of students, it is required. Also for the students who are going to become an entrepreneur, or who envision to become entrepreneur, who envision to have their own startups, there as well you need to have IP, because the competition, the way the ground is being laid, and I'm sure you all understand that if you have your IP filed, you go for funding and the scenario changes. The angel investors or the seed capital paying guys, they actually many times appreciate that, okay, this team understands what is to be protected, how it is to be protected, and then they believe in their product, they believe that what they are going to present to the market, and it obviously raises the confidence quotient of the party or the presenter or the listener where you're going to present something. So that's the role IP plays. And also, once you have something, you can have the license costs, which I presented, revenue from the licensing. As I presented the big shots in the industry, they are getting revenue. So if you have something, some monopolized product, you can get revenue out of it. It may help you run your operations in a long run. Then, like say, why IP? I believe I said, I briefed you many things. Now, what is IP? What we say that what is intellectual property? Yes, if we compare it, it is property. As we say, it is something which is owned, which is in possession of an individual, which belongs to someone. Important type of properties. We believe in ourselves. If we say, and we all know that it's a real property, I have an apartment over there, I have a car over there, I have few pen of myself, I have a laptop of myself, then intellectual property is something which is my expression, which is my creation, my thoughts which I am putting in. That's the reason we say it's intellectual property. And I'm not sure how many of you are aware of this intellectual property. Many a times is much more valuable the assets which we are having, like a house, like an apartment, like a scooter or a bike or a laptop, because they are limited by one or the other sense. Now if we say intellectual property, that is my intellectual assets, there it can go to leaps and bounds. It has no limitation whatsoever. And if I create something which is really unique, which is mass appeal, which is going to impact the masses or change the social scenario, so you can imagine that it has plethora of avenues to reach for, and the revenue can be generated humongous. So by definition, I say any product or human intellect that is tangible but has some market value is the intellectual property, and the rights over that property becomes IPR. That means intellectual property rights. So it's very similar. You have an apartment, you go, you get it mutated, you get it registered, and it's in the name of an individual, that is maybe you, your father, your family member. So that belongs to you, and whatsoever you decide to sell it off, dispose it off, you simply sell in the market, and any other a genuine buyer comes in who is interested in that property, he occupies it after paying the desired amount, and the hand exchanges. Very similarly, in IPR this thing happens. Like if you have an invention, so it's like in a house, you sublet, you have a room, you say okay, I'm ready to give it on rent. Or if you construct few rooms, you say okay, I can give it to rent to 10 people, I can collect from them. In a similar fashion, if you have your IP, you say I am licensing it to multiple entities, I am getting the licensing cost. And if you want to sell it off, you can do it at an outright one-time sale, and the fellow who is interested, the company who is interested, can exchange hands by paying the desired amount. This is something which I was trying to brief. Like I have taken a small example in my slides, if you can see over there. It's a vehicle which I have taken, and I'm terming it as a real property. And if you see this property, what all we can do through this property or with this property, with this vehicle, actually we can say like, we can drive it, we can sell it, we can buy it, we can rent it, we can mortgage it, and we can also exclude others from driving. Now this is foremost the important point. We say exclude others from driving. Come to IP. If I relate in this very similar term, you can see there is a vis-a-vis every cell, every column we can map. What we can do is we can use our IP, we can sell the IP, we can license in IP, we can license out IP, we can mortgage, and we can exclude others from using. And I'm sure after looking to this slide, you can very well compare that vis-a-vis where we are sitting, actual property, what we say, and our IP. So IP categories. So what I try to do, I try to bifurcate the intellectual property in couple of broader sense. If I say two categories, I'd say industrial property and copyrights. People generally say they are 4, 5, 6, 7, but I have done this in a manner to make yourself much more acquainted, and as a thought process, understand better. It has nothing to do with the hierarchy or the categorization something. This is not hardcore or stuff. This is simply brute force thing which I have tried to present over here. So it's like in intellectual property, I have divided into two. It says industrial property and copyrights. In industrial property, I am going in. First, we say there are patents, there are trademarks, there are industrial designs, there are geographic indications, there are trade secrets. On the other hand, we say copyrights. Then copyrights, we have literary work, we have artistic works. And in literary works, if we say we have novels, we have poems, we have plays, we have films, musical work, everything comes into the literary work. Artistic work, we have drawings, we have paintings, photographs, sculptures, architectural designs. So it's a broader sense. Nothing is hard and fast. If we can put in on the you can say right side bracket, we can distribute in one sense. It's the left side. I have tried to distribute that what it is and what is industrial property and other things, just to make you understand in a much better way. So we start from the copyright. I'll try to cover that in a very quick fashion, then we'll jump on to patents and why it is at all required. The more emphasis will be on patents. So if we say copyrights, copyright, it protects an expression of ideas fixed in tangible medium. And I'm sure you are aware, you guys are convinced like or aware of what is a tangible and intangible medium, something which you can see and something which you cannot see, maybe what you can feel which you cannot feel. So copyrights, they have a limited term, that is 70 years plus lifetime of author. It can be passed on, as in inheritance, and then we have protection, that is statutory. We have the registration stuff through which we can get it. There are infringement of copyrights as well. I'm sure you must have seen there are multiple cases which on and off come in the newspapers, like certain movies they are being produced, and the writer, one writer sues another and sends a notice that okay, this was my story and it's being used in this particular movie. And so these are, or maybe in some paintings, that this was my idea, my painting, I have drawn it somewhere else, and then other one has taken it over. So it is like protection is available to both published and unpublished works out there. Examples like we say poems, software, books, artwork, and the symbol is pretty much, you see the C and circle, it says copyrighted. So there are generally we have 6 exclusive rights under copyright category. We say right to reproduce, right to first publication, right to translation, right to perform, right to telecommunication, right to adaptation rather. This is generally like the first one who creates, he may assign the rights to reproduce, translate, or whatsoever. So it's again depends on copyright to copyright and the owner to owner who actually owns the IP. Like I said, copyright owner may allow others to carry out the above under a contract or assign rights to another person or body, that is a publisher. So like if I'm a writer, I write something and I grant a right to a publisher to use it, to modify it, to present in the form of book, compile it and sell it. So I am assigning some rights to a publisher, but everything happens under a contract. Then there is again a notion, we say copyrights, it exists automatically. So generally we say there is no need to register it or even make a formal claim, but if we have to have our own rights, we are deciding to move ahead, then to justify, to sustain our right, we should go for and we should move ahead with the copyright stuff and register it. And it provides protection for a whole work, even also for parts. It does not provide protection for ideas or principles, something which is in infancy, I cannot claim copyright for, or something which is a known principle which is there, I cannot claim copyright for. Infringement of copyright is not a criminal offense generally, but what we believe, but it is a civil offense as well. And the penalties may forfeiture of your materials, damages, prevent further infringements, etc. Fair use policies can be there. We say for educational purposes it's permitted. There are certain artistic works which people say that okay, fair use license is there and anybody can use it, but by giving due credit. So fellows, just to like remind, whenever you use anything, even in my slides as well, you must have seen the photograph or any piece from wheresoever I have taken, give credit. At least the inventor, the generator, the writer, the author, it should be given. That's what I believe. Now for the computer programs, that is the technocrats, the audience, which majority of the people, you guys are there, you guys are listening. Challenges, software is it's the hybrid nature of the software. What we have, it is an expression, that is a source code which provides a function. So I'm sure you're getting what I'm trying to tell. That is, you have a source code, the expression which you have written in a language. I am speaking in English, so in a similar manner computer understands programming language. So you put in your expression, you provide a function of which does some function, and the protection of these programs, they are the literary works, you have the copyrights of the source codes. Generic codes, they cannot receive any protection because they are so generic, everybody uses it. So the libraries and other stuff, maybe the creator, the company who owns it, they have the protections. The underlying ideas, they remain unprotected. That is the functional aspect of the program, it remain unprotected. Then there is another mechanism. We move ahead and we get it filed as patents, and there are things which I will be presenting. Next thing comes in trademark. So I'm sure by now you must have observed what I have done is I have taken the right side of the portion. I jumped in the copyrights. I tried to wind up pretty soon, and now I am moving in a chronological order. I'm moving down to top, like bottom up approach. I'll be taking trademarks and then other stuff. Then what is a patent? The trademark, you must have observed many times. You have crossed the market or anywhere else, even in the companies. Many industries, logos, even the soap, the toothpaste, other stuff which we generally buy, you must have seen TM or encircled R written over there. So it is once we file a trademark, we write TM. When it gets registered, we convert it into a encircled R. So by trademark, we say it's a, and also the name suggests it's my trademark. It's a distinctive sign or an indicator used by a company or an individual or a business organization to uniquely identify the source of the product. Like if I say X product belongs to, so generally immediately rather we know that okay, yes, it belongs to that particular company. So it has an unlimited term with continued use. The protection is common law and the registration of the trademarks. An infringer, what he or she does is, like if we say, we can take an example, like we have Colgate and we say Colgate, so replacing G with J and using a misnomer kind of an imprint of that particular packaging. So these are kind of infringements that generally people they try to do. And you must have seen in the market as well, like we say 99999, we say 66666. So and maybe with 111 replacing 16 with a very similar 9 and then 99 using the same impression. So if generally what people do, if someone is already established a business house, they try to infringe by using a confusingly similar name. And our case was pretty much in the offing, and many times like big burger chains, they have the things, and I'm sure if you go down to the internet, you scroll it, there is a company who moved into a country like Malaysia, and they were selling burgers across the horizon, across the world with their brand name. But that particular name, it was already protected under trademark laws of that country. So they lost, and they are not allowed to use their name, which is being used across the world. So this is, if I say, maybe the beauty or maybe the implication of IP laws. Then there are service marks. Service mark is generally the same as trademark, but there is a small exception, that it identifies and distinguishes the source of a service rather than a product. It's the service which is being provided. So the key points of the service mark: it has to be distinctive, it cannot be deceptive, it is not used to identify a product, a source of a product is identified through this service marks. Others cannot use a same trademark, that is without the permission of the owner, and it cannot be obtained by registration with Patent and Trademark Office. It can be used by, and generally it needs to be renewed. Then third thing come in trade secrets. Trade secrets are something which are passed on generation to generations, and there are many industries which try to use these as their trade secrets. Nobody else could make it. And like if we say some sort of masalas which are going in, some sort of formulas going in, if you can see, and you go in nook and around in the corner to a small family shop being driven out of generations, like a sweet shop being set up, and when we see there is, okay, this particular item belongs to this sweet shop, and it's been like 50, 80, 100-year-old company, the knowledge is being passed on to the grandfather or great grandfather to the son and to the immediate son, and that's how it evolves, and nobody else is able to copy that, nobody else is able to generate that. That's how we say it's a trade secret. So it's a formula, a practice, process, design, instrument, pattern, or information used by a business to obtain an advantage over competitors. Like we say, a very major soft drink maker, they have their formula as a trade secret. They do not divulge it to the people, and it's being said that it's protected in a safe out there, and it goes on management to management, but it's not open at all anywhere, and that's how they are able to sustain and maintain the typical taste of their beverage which is going around. So trade secret, it is unlimited term with continued use. It is protected. It's no specific protection under the law as such. If we say, you can use non-compete and non-disclosure agreements, and the employee and the person, they are under agreement. It discloses the information. Examples which we have tried, it's a secret formulas, it's the manufacturing processes which we have there, it's the chemical recipes which are there, product specification, even for the treatment methods, and even for our, we say, some massaging treatments down south portion of our country which people are doing in. So it's all in the trade secret, that at what time, what kind of oil has to be applied, and which benefit it will reap in, So it goes in trade. Then comes in geographical indications. It is again one of the major type of IP, where we say it's the name or the sign of a place or a city or the country which speaks for itself that okay, this thing belongs to that particular geography, like intend to designate a product quality that highlight brand identity and even preserve the cultural tradition of that particular area. Like in India we say Kolhapuri chappal, then we have Banarsi sari, we have even Swiss watches. We say they are pretty much thing. In India we say Darjeeling tea. So these are all like geographical indications. If we say a city and we say that city is particularly famous for these things which we have shown. So many things are more things are there which are known as geographical indications worldwide, and they need not to be, nobody can protect them. Actually they are by default, the city is being known by. So if an individual go ahead and file the IP for it, will be denied because it is a public knowledge. Now next thing, now we are moving on to patents rather, and how it all started. So it says an obvious question we all have, or we all must have rather, when was first Indian patent filed? And we can generally say in what happened in February 1856. A first legislation, it was introduced to grant what was termed as exclusive privileges for the encouragement of inventions to new manufacturers. That was in India. I am speaking about categorically. That is 28 February 1856. Then subsequently, once this legislation came in and the rule came in, within few days, that is after 3 days, on 3rd March 1856, a civil engineer and inventor that by the name of George Alfred de Panning of Calcutta, India, he filed a petition for grant of exclusive privileges under this act, and for a machine or something which like efficient pankha pulling machine. But that in during those days, I'm sure if you must have seen the old movies or something, fan, or it was a cloth fan on the roofs which are used to be pulled up by an individual standing outside the room. So he made a sort of machine which used to do the work of pankha pulling. That is the fan, that the big piece of cloth overhead, and it gives the air and it refreshes the room. So it was filed, and it was actually numbered as officially number 1 of 1856. Then this fellow, that is George Alfred de Panning, moved on and filed secure patent number 2, 4, and then long and numerous other long list goes on. So this was an Indian scenario. Then we have in US scenario, there is a signal light there. I have tried to rope in the picture, and it says first US patent issued in 1790. So if you see precisely 66 years before, then we have, and it says to Samuel Hopkins, who in 1781 settled here and something, and he got the patent. It was granted by first George Washington. It was signed by the George Washington, that is the then president, and that patent, it covered the making of pearl ash, and on this, that the ingredients of soap manufacturers was founded women's first main economy. So that's how economy is being driven. Like you file a patent, you get it awarded and use it, and then move on. Next, I have tried to compile what kind of scenario or the stuff we see in and around, and they are protected, they are not protected. So now by the time, I believe, if you guys do some sort of introspection, if you guys do some sort of hang around kind of things, I can certainly tell you, look around and go through. An Indian scenario, again I'm saying, you may not see a patent number listed, a patented stuff, but global thing, if you go around, and practically majority in the US case as well, if you see our toothbrush, our toothpaste, even vehicles, we have bags, chairs, and on all the items you see in and around, it's listed out there, patented and the patent number this, or patent filed by the application number this. Even many toys you can see there, it's there. Even in mobile phones, the companies, the high-tech companies own plethora of IP, and 4G is going around, and 5G. And here I might like to present one thing, a very interesting scenario. mobile phone companies are coming in like Apple. They provides iPhone to the market. You know, because of IP licensing, company X actually ends up paying few dollars to company A, B, C, D, E, F, G, because they are, or rather they have to license technology from the other company. So I was reading an article the other day, and so once like one 5G technology comes in, so many of we feel that company like Nokia, they are just sitting around. But my dear friends, once you go through it, majority of the, or many 5G patents are being owned by Nokia as well. So they still be getting licensing money. Same goes for Qualcomm, same goes for Huawei or other companies. So there is a lot of interlicensing kind of things, and so they have all kind of arrangements out there in the market that we will take this patent, we will do this, and still they sue each other for kind of, you know, royalties and the IP infringements. Moving further, we have computers, lights, lamps, tables, even napkins. We have blades. Prominent company who provides the razors. It's being said, and it's the world leader. No need to name it, but on a single piece of razor, they have more than 200 patents on their name. So can you just imagine that the razor stick, it has that much of IP? So just need to go around, just need to circulate, need to gauge around that what kind of IP is out there. Soaps, shampoos, then we have clothes, we have shoes, and many more in and around the area which we look around. And the funniest part is, if you look around the mouse strap, it is one of the most patented item, and which has like close to 4,000 patent applications already filed. So you can always say who is making our life merry. Then I'll very quickly move on that general parts of patents. Now, my dear friends, here also I would like to answer one thing, or rather tell you, filing an application, there are a couple of things which we do, which we have. So if some innovative idea you guys have, or you guys come across something which you believe is novel, which is patentable, you guys have to file an application for it, and to file a patent application with the designated office of our country, like maybe in India, and if you go to any other jurisdiction, you have to file patent over there. So there are patent laws which typically govern everything. As in part of patent, we have title, abstract, background, summary, detailed description, then we have claims, drawings. So you might not be able to understand what these all are. So, and frankly, you need not to at this phase, but what you guys should know, that you have to write a document which should have everything what you believe is novel, what it is covering down, what it takes to move ahead, and then a techno-legal fellow can come in and draft a patent application for you, who was a specialized fellow. This is something which I think I should be skipping because of the time scarcity and the stuff we are looking in. Broader sense, I have tried to explain that what title means, what it should do, and this is something which a patent drafter is already aware of. So if you guys can do yourself, pretty much neat, but writing claims that involve some legalities, so certainly you should take help from an expert, because this is the claim that you make for your invention, which goes to a length that infringement, invalidities, and licensing, everything is being taken care by the claim what you are writing in, what you are doing, or what you are claiming as your invention. And your claims should have the sufficient support from the detailed description or the specification part which that expert is going to write. So it is all about the laws, which has to be certainly taken due care of, and majority of us which we don't know, and obviously it comes at a price, but from like our government nowadays, they are also supporting a lot of things. We have different cells where inventors, innovators, students, they can approach and can get their application filed in a fraction of a cost. Generally we say patents, so we have three basic type of patents. First one, we say it's a design patent, then we have a plant patent, and then we have utility patent. So design patent is something, if you believe you have a jewelry and you have seen, so ornamental design, all those kind of design, if you have some sort of machine, some sort of tire, you can actually have the design patent filed for it, and they have a certain time limit, that is the 14 years time limit, and they are not subject to maintenance fee payment for these design patents. Otherwise we have to pay maintenance fee or the subsequent patents. Then we have plant patents, that is modified, and we do a lot of mutants, hybrids, or newly found seedlings. So we have a category where we can file plant patents as well. But majority, like I said, utility patents. So majority of the patents, they are the utility patents what we are bringing in. 90% of the patents, they are utility patents. So that means any invention which is new, which is useful, which a useful process, it is a machine manufacture or composition of a matter, it comes under the category of utility patents, and it grants a 20-year right to that applicant to as to monopolize, to as to license, and to move on. Generally, again, a question comes in, and majority of the students and the academic community, they ask like, what is the difference between a publication and a patent? Why we should move ahead to file a patent? So it's a very quick thing what I have tried to take on in. Publication, it represents a study like any analysis, that is case study. Patent represents something which is novel and useful and non-obvious. Then we have publication doesn't give you any legal right, patent gives you. It publication may or may not be presenting an invention or anything new. It may be something, a case study, something which you are believing. It may or may not be applicable to anything which may be considered useful. But for patents, we have something like it stops someone from selling a fake product and infringes upon the claims of inventor's product as well, patent. So it's stop that malpractice doing candidates. Now here what I have tried to bring in the data stuff, like PCT applications are there, how many PCT filings are being done. You can see the sorry state what we are in, but this number is improving. This number is improving drastically for our country, and we are moving towards that. But genuinely, we have a lot of things to achieve, a lot of things to catch up. University patents, if you see in US, out of 16, these are PCT applications. Again, I am telling it's not the country application like US and not in US. It's US as in WIPO, JP as in WIPO, and WIPO is Worldwide Intellectual Property Organization, and whereby I have taken the data. It's 16 data. Why IP is not enforced? You must not have seen that the challenges which we are going. So it is like administrative delays are there, are damage culture is not there, we have a lot of lack of training and technical expertise out there, and IP offenses, they generally seen as a private offenses. So we need to create awareness among ourselves, among people, that why see, we are living in our house, we let it protected, we get it registered, and we do not let or we do not allow anyone, and only if when we are allowing, we obviously charge, we put it on rent. So very similar stuff we have to go for this IP is much more revenue generating asset. All of us must understand that. IP scenario current, we say like US, if we say that it has the strongest copyright, patent, trademark protections in the world, and the total stock of IP valued is around $5.8 trillion. China is ranked third, India is ranked 9th. We are picking up pretty fast. Scenario was not 2 decades ago, and I have not presented here, but just to let you know, last year itself, Chinese companies, they filed 43% more patents than anyone else in US. So you can understand, and this was not the scenario a few years ago. So past 5, 6, 7 years, they have taken a leap and bound growth, which I believe as an Indian scenario, all of us should take it, all of us should enter it. I have tried to present a chart which shows a positive growth of us. It's positive, but we need to take it to an exponential level if we want to catch across the world. China, we say obviously just before 2000 they were like going into doldrums, but after immediately past 10-15 years, we have seen a dramatic increase in patent activity. They are hiring people, they are sponsoring researchers, they are providing a lot of support in doing research activities. So this is something which has to be done in India as well now. This is China's growth map, it's putting up. Patents, we say generally we have legal requirements, and it says it has to have some utilitarian stuff, it has to be novel, it has to be non-obvious. So these are three basic requirements. I'd say utility, novelty, and non-obvious. So by utility we mean anything which has some utilitarian value. By novelty I means nobody should have done it before, or maybe at a subsequent improvement thereof. Non-obviousness, which we mean that anybody out there should not just take it, okay, it is obvious, anybody could do it. So it has some certain will in it. That is, if you disclose to a subject matter, so it is not obvious to a person who is ordinarily skilled in the art, and it should be something which is actually novel. What can be protected? Novel, we say, not previously known or used by others, have a known use, or if it can produce a concrete or tangible asset. Then we say non-obviousness, that is for CETA we generally say person having ordinarily skill in the art, they should be able, and things that cannot be patented. It includes idea, that is law of nature, scientific principle, discoveries, they are not patentable at all. So we need to keep these things in mind. Then we comes to the legal requirements. What is it? That I already told you, that is utility, novelty, non-obviousness. So this is something, a chart which I try to draw for some handy reference. Utility, again, essays. I remember all these things by a codification. We say PMMC. If you look at it, it says process, machine, manufacture, that is article of manufacture. By C I meant composition or matter, and then fifth is an improvement in one of the above four classes. So it says process, machine, article of manufacture, and then we have composition of matter or a subsequent improvement in any of the four classes which I mentioned above. That is primarily we mean by utility. Invention, it should fall within up to 5 classes which we named in. It should be useful for some purpose, it should be credible, it should be specific. Non-credible invention, it says a perpetual motion machine, it is a non-credible. Then we say a non-specific invention. It says a compound X may be useful in treating unspecified disorders. So we are not specifying anything, we are not mentioning even anything, so these are not patentable at all. These will be outrightly rejected. Non-obviousness criteria, I can say, like if there is an invention A and B, if we combine them, and A and B, they are known in the art, so the invention is obvious. As if we say combining A and B, anybody can figure out, okay, this becomes obvious. So non-obviousness has to be that a person who is generally skilled in the art at the time of invention was made, he should not be like immediately struck him over. So it should not be obvious by combining multiple things, few things. So there was a case after which this thing came in. Novelty, I already explained that it has to be used publicly and offered for sale to the public. Something for the priority, so it is something which is new altogether. Then there is a part specification which I am not going into the detail. This is something which a legal or the techno-legal expert has to be taken care of. Maybe you can go through the slide deck once it's up and running and upload it so that you can take care of it. Then third, we have this is utility patent which I have drafted a chart for. We have utility application, then standard, and the continuing. It says provisional, non-provisional, and then continuing is like generally we say, and I can give you a very clear example. We file an application, let us treat it as a father or a parent. We can file as many application down the line of that parent till the time it is not granted, that till the time it is alive. We can have divisional, multiple, we can have continuation applications, we have continuation in parts, and these are all terms of the IP. Once you drill down it, you will get acquainted with. So generally we start off with a provisional application. If you are not very ready, you file it up, you get a date secured, that is the priority date, and which plays the utmost role in getting a patent for, and that date you secure immediately. If your patent is granted, once you file a non-provisional, your priority date will be the date you filed your first application. Requirements for a non-provisional application is it has to have some specification, drawings, and the claim sets. Like in India, we have 1+9, that is one independent and dependent claim set rule, and once it is granted from the priority date, we have 20 years for a particular application. So during that time, we can enjoy the monopoly, or we can license it, we can enjoy our rights. For provisional application, if we go by, we do not need to include claims. If you see, the contents as required, we have specification or drawings. Why it is required? So anybody, any novice user or an inventor or a researcher, if he comes across an idea, he can simply put it in a paper, use some X form as mentioned by the patent office, and can certainly file it with the patent office. Then it's like 1 year time frame starts. During that 1 year time frame, non-provisional application, that is a formal application or a regular application, needs to be filed without any fail. If you fail, then it's abandoned. Life cycle: once you file a patent application, non-provisional or a regular, 18 months time starts, it is published, then it goes through some sort of prosecution, examiner examines it, get back to you with some queries, and if everything is through, your patent is rejected or is granted if it's through. If its examiner is not satisfied, it rejects it. Once it's through, you grant it, then your 20-year term starts from the day you filed your first application, and then it's expired. And during the course of that time, there is a fixed term. You have to pay a maintenance fee after every year or 5-year term. There is a term which is very well defined in IP laws. Then I believe we are moved on to some stuff which says the dates, which I was mentioning, that we have filing in the application date, that the date on which a patent application is filed, the first date that you decide and you move on whether it is a provisional or a non-provisional application. Then we have a publication date, issue date, grant date. The date on which a patent is issued or granted is this date. And then we say patent publication, that is the date on which a patent application is published. Then we have a priority date, the date from which a patent application takes priority. That means if once I started, I said a patent is live and we are filing a subsequent application, so we are claiming a priority from the parent. And a very question must have come to across all your minds. We have a huge data out there in the patent. One can be a mechanical, then we have computers, AI, and subsections. There are a lot of classes, there are a lot of categories. So there is a mechanism devised which is known as patent classes. It is a hierarchical system. You can go around on WIPO. It is listed in India. We are using it. So it is like international patent classes which we are using it. So that if you are writing, you have to write explanation that your application, let us assume if you have devised a new air cooling system, so there is a particular class which says that okay, this falls in this air cooling mechanism system, and you select that particular class. So it helps the examiner, helps the inventors, help other people to let it look. So it's a proper indexing mechanism which is adopted worldwide as a standard. So I believe in and this is somewhere we end up our session, and given a broadened horizon and scope, like where are we and what we have established, and I try to bring in a general sense about patents and IP. And to all the student fraternity out there, my humble request and a submission: please try to document, please try to put in the IP or the provisional applications, harness the intellectual asset potential. I'm sure that is going to be a lot more fruits of your labor which you are putting in, and certainly then you can see yourself grow more and get the country's economy grow leap and bound, or moreover exponentially. That is something which we direly need to all the researchers and innovators out there. Thank you, and all the best. Take care. Bye.